One of the questions that comes up a lot from potential clients is why do we have to pay a retainer? And I think what that comes from is the fact that all the television ads and all that kind of stuff come up with car wreck cases where all the lawyers say, you don't pay us if you don't win. You only pay us if we win your case. And that is kind of a unique situation that really doesn't apply to these solar panel cases. In a car wreck case, the reason lawyers can do that is because there's an insurance company out there like State Farm or Allstate or Geico willing and ready to pay the damages if they win the case. So if they have a good case, there's no risk to the lawyer that they're not going to get paid. Now, in these cases, these solar panel cases, there are 3 or 4 ways we could do a fee agreement. One would be where you just simply pay me by the hour. And in a commercial litigation case, my minimum fee is $10,000. I work it off by the hour. And the way that works is you would then be taking on 100% of the risk. Whether I win or lose, I still get paid. If on the other end of the spectrum, we do a pure contingency, we don't charge you anything unless we win, then I've got all the risk. And the problem with me taking on all the risk is that there are no insurance companies out there standing by to pay my fees in the event that we win. It's going to be part negotiation and part the judges are going to have to agree to award them. So there's some risk there that I might not get those on the back end. But in our fee agreements, every one of them limits our top side from the client. Now, they all say that if we get more from the lender, we get to keep it and we'll refund you your retainer. But in the event that we win the case and you wind up being the one ultimately responsible for the fees, we limit our entire fee to a total of $10,000. So here's all I'm asking is that if you will take the risk of $2,500, I will take the risk on the $7,500. So we think that's a fair allocation. That allows us to pay our staff, get these cases moved forward. It's essentially a break-even proposition for us to be able to get the case to the arbitration on that kind of a fee. We're very, very frugal. If you know much about lawyers, that's an unusual word around a law firm, but we're pretty frugal. And we can get there on the $2,500 plus the filing fee. But once we get there, then the risk is on me. If I don't win, then you don't owe me another penny. And so we've gone back and forth with a lot of clients and a lot of people trying to figure out just what the right balance is. And that seems pretty fair. If you'll take 25% of the risk, I'll take 75%. But we use that fee to like I say, help us get there, pay our overhead, pay our staff, and put us in a position where we can go toe-to-toe with the big guys.